This program is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. My name is Ann Grover, and I'm a principal with the law firm of Joseph Greenwald & Lake, and I work in their family law practice. Most folks have heard the term whistleblower in the news recently, but what does that mean? What protections are available to you if you report on a federal employee, federal contractor, or private company? Today we have two guests to talk about whistleblower law in the federal arena and the private sector. I'm joined tonight by Joseph Creed and Matthew Stiff. Joe Creed is a trial lawyer and appellate attorney who represents federal employees in all aspects of employment law. His practice includes all types of employment disputes, including suspensions, demotions, wrongful termination, discrimination, harassment, retaliation, and all aspects of federal whistleblower protection law. Joe is the author of Employment Rights of Federal Employees, a chapter in the Maryland Employment Law Desk Book, which is the go-to employment law resource for lawyers throughout Maryland. He is a former employee co-chair of the American Bar Association's Federal Sector Labor and Employment Law Committee. Joe is voted a 2019 top lawyer in the areas of employment law and appellate law, as featured in Bethesda magazine. He is a partner in the law firm of Bramnick Creed LLC, which is based in Bethesda. Matt Stiff is a partner at Katz, Marshall & Banks LLP, a DC-based firm that exclusively represents plaintiffs in whistleblower and employment discrimination cases. Matt has represented dozens of whistleblowers in the financial, nuclear, aviation, healthcare, pharmaceutical, medical device, and other private sector industries. He primarily focuses his practice on corporate whistleblower matters, which includes representing individuals in whistleblower reward programs and employment retaliation cases. He also represents relators in qui tam lawsuits filed pursuant to the Federal False Claims Act. Matt was voted a Washington, D.C. Rising Star by super lawyers in each of the past 4 years. Joe and Matt, welcome.
Thank you. Great to be here.
Joe, could you tell us, what is whistleblower law?
So I represent primarily federal employees. So when we talk about the federal sector, and we talk about whistleblower law, we're talking about a law called the Whistleblower Protection Act. And that's simply a federal law that protects federal employees who make disclosures of certain information within their federal agencies. It protects them from being retaliated against for doing that. So it protects them from having their agency or higher-ups within their agency take some sort of adverse action against them, be it a termination or some other adverse action against them in retaliation for making that protected disclosure.
And Matt, how does that differ from the private sector?
Well, in many ways it is similar in that the same structure exists. Whistleblower statutes that prohibit retaliation against employees because they raise concerns usually involving matters implicating public health and safety, or perhaps it might involve financial misconduct by a corporate entity. So we represent these individuals in the private sector, and they are going along in their day and doing their jobs and trying to provide for their families. And eventually they uncover evidence that suggests that their employer is engaged in wrongdoing. They might raise concerns about it, and they suffer retaliatory adverse actions as a result of that. Maybe they're fired, maybe they're demoted, but ultimately we step in that situation and represent their interests and hopefully achieve a good result for them.
And what's the difference, Matt, between retaliation and a reward program?
So an employment retaliation case under a whistleblower protection statute involves what we just discussed, this notion of the employee engaging in protected conduct and then suffering the adverse action because of it. A whistleblower award program is a little different because it doesn't necessarily require retaliation to have occurred. It's more a function of that employee bringing information to the attention of a government regulator, and then that regulator takes some investigatory and enforcement action against the employer. Maybe it's the SEC as the regulator, and they're investigating a Wall Street investment bank that violated securities laws and perhaps defrauded Main Street investors, wiping out their savings. And an employee of that Wall Street investment bank uncovers that wrongdoing, and they report that information to the SEC. The SEC investigates, then takes enforcement action. They might file a lawsuit in federal court and force that bank to be accountable for what it's done. Ultimately, ideally, there's maybe a settlement, a monetary payment, which can be very substantial into the tens of millions, hundreds of millions, sometimes billions of dollars, depending on the underlying allegations. And that SEC whistleblower award tipster, that person who originally brought that information to the attention of the regulators, they may well be eligible for an award depending on the assistance they provided. And it can be anywhere from 10 to 30% depending on the given whistleblower award program. So again, not necessarily any retaliation that's occurred to that person. Perhaps they were able to submit that information and the employer never learns it was them. But that's distinct again from whistleblower retaliation, where there's that adverse action that that employee wants to challenge.
And Joe, in retaliation cases, does it have to be a termination of employment? What are some other types of retaliation we might see?
For federal employees, it doesn't have to be a termination of employment. Really, almost any adverse action that's taken against that employee, if it's done as a means of retaliating against them for a protected disclosure, then that can be considered retaliation. So that could be a removal, it could be a demotion, a suspension, it could even be something like a reassignment. If it's done to the employee for the purpose of retaliating against them, then it can be considered an adverse retaliatory action.
And Joe, I'll start with you, but how does one determine if it's done in retaliation? In today's employment arena, it seems like that might be difficult to determine.
Sure. For federal employees, if the fact that they've made a disclosure, a protected disclosure, so if they've reported some illegal conduct, what they believe to be a violation of the law, or a gross waste of government funds, for example, and then an action's taken against them, and it can be shown that their disclosure was a contributing factor in the action that was taken against them, then that is what has to be shown in order for it to be considered retaliation. So it doesn't even have to be the only factor or necessarily the most important factor. If their disclosure is taken into account and that's a contributing factor to the action, then that's considered retaliation.
And Matt, what are some of the things that in the private sector you might look to show that it was done in retaliation?
Sure. So that's often the bulk of what we're doing in terms of representing these individuals. We're looking to uncover evidence that connects that protected conduct, that whistleblowing complaint that was raised, perhaps internally, perhaps to a regulator. And we want to link up the two. We want to link up the termination decision. We want to link that up with the protected conduct. Sometimes we show that through what we call temporal nexus or temporal proximity, this idea that you engage in protected conduct on Monday and 5 days later you're fired. That is a very short timeline, and an inference can be drawn that it was that protected disclosure on Monday that ultimately contributed to the decision to terminate your employment. We also will point to incriminating remarks made by management officials. So perhaps our client in a board meeting says, I think that this course of conduct in which we're engaged violates government contracting law, and we are defrauding the U.S. government. And in response to that, perhaps the CFO says, I can't believe you would say that. That has angered me. Get out of here. They express anger and outrage at raising the concern. We would point to that as evidence of retaliatory animus. Or perhaps we would establish that whatever reason is given for that adverse action, that it is not worthy of belief, right? It's something that's false or not credible, or the reason that's given by the employer to justify that termination, it may shift over time. It might be one thing when they're initially terminated, and then later on down the line, they might change their story. We're going to point to that and say, they are, moving the goalpost on us because they don't really believe this reason, and they can't point to the true reason, which is that this individual raised that complaint at the board meeting, and it angered management, and they felt that they had to move forward with that retaliatory termination. So we're always very keyed in and focused on creating that causal nexus between the protected conduct and the adverse action.
And Joe, in the federal sector, when you believe that you've been retaliated against, is there anyone to whom you have to make some sort of complaint?
Well, for federal employees, there's not a strict reporting requirement in terms of who you report that to. In fact, there's a number of different people that a federal employee can report to be considered a whistleblower. Most commonly, they may report to their supervisor or someone higher up in their supervisory chain. Also, most federal agencies have an inspector general, and that's a person whose role it is, in part, to take complaints like this and investigate them. So a federal employee can always report to their inspector general. There's also a separate federal agency called the Office of Special Counsel, which exists to hear whistleblower complaints, to investigate those, and also investigate whistleblower retaliation allegations. So a federal employee has a number of different options in terms of who they can report to, and I think the law is intended to be broad in that sense, to encourage people to come forward, to make disclosures, and rather than have a strict reporting requirement, to allow a range of people that they can report that to.
And Matt, does that differ at all in the private sector?
It's pretty similar in the private sector. You can, as a private sector whistleblower, report your concerns internally to management, usually your boss or maybe your boss's boss, perhaps some other supervisory executive in the company that has responsibility for, let's say, financial reporting if it's a financial misconduct issue, or maybe a general counsel, an in-house corporate lawyer who's responsible for investigating these kinds of things. As long as the complaint is raised internally to responsible management officials, that complaint should be protected. The individual can also report externally to governmental authorities that have regulatory responsibility for the given industry in question. So imagine an airline pilot who is inspecting a jet plane. They're about to fly, commercial flight, and they are concerned after inspection that that airliner is not safe for flight. So they can report that concern internally. They can raise it up the chain of leadership. And if they were retaliated against for raising that concern about airline safety, they would have rights under the federal whistleblower protection that applies in that space. They could also externally report those same concerns to the Federal Aviation Administration, the FAA, and that complaint as well would be protected under that law. I think one wrinkle, and I think this applies in both sectors, I'm not actually sure about that, but a little counterintuitive is that it's not necessarily protected conduct for an employee to report matters to media outlets or to journalists, even though they feel as though they're doing the same thing. They're raising alarm about an important issue affecting, let's say, public safety or health. They're trying to get the message out there, but courts and Congress and legislatures have decided that the scope of that protection, the scope of whistleblower protections, should not encompass reports to media outlets. And we see this in our practice. Sometimes people go to the press and they share their stories, and it's commendable that the motives are correct, but the employer might be able to point to that and say, that's not protected under the law, even if maybe you engage in some other protected conduct, and we're allowed to fire you because you made that report externally to media outlets. So you've got to be mindful of this as you sort of plan your path forward if you're intending to raise these kinds of concerns.
Is that the same for federal employees, Joe?
That would be true for federal employees too. And again, remember the purpose of the law particularly in the federal sector, is to encourage people to make disclosures and to report things that they become aware of internally so that those issues can be addressed within the government. The other sort of nuance to be aware of as far as federal employees are concerned is it also makes a difference exactly what you're reporting. So there are some things that may be classified information. There's some information that it may be illegal actually to report that externally. And so for a federal employee, they have to be aware of what they're reporting, whether it would violate a law or an executive order to disclose that information. Now, even in those contexts, there is an internal reporting mechanism within that agency, and usually it's the Inspector General, so that the report can be made confidentially and still be investigated and addressed. But yeah, it's important for a federal employee to be aware of the information that they're reporting in terms of the nature of that information, whether there's any limitations on who it can be disclosed to, and then based on that determine who to make the report to.
Joe, you talked a little bit earlier about the different people to whom a federal employee could report retaliatory conduct. Do you have to choose one or the other if you've got a couple of different options?
You don't necessarily have to choose one or the other. I mean, a federal employee could report illegal activity to their supervisor and then also report it to the Inspector General. It's not necessarily an either-or situation. And again, the focus is on encouraging people to make these reports. In some cases, it may be that the person's supervisor is the person who is engaging in the illegal conduct or the conduct that's being reported. So they could still report to that individual. It would still be considered protected whistleblowing if they did. But for that reason, there's other options available as to who they can report to.
And Matt, how about in the private sector? Do you have to pick your poison?
No, you don't necessarily have to pick your poison in the private sector. You can report internally, just internally, and still be protected, or just externally and be protected. It's often the case that our clients are reporting to both. Perhaps they reported internally, management didn't do anything to correct the issue, or they felt they were being subjected to retaliation, and so then they go to the regulator, then they go to that higher power that might be able to step in and take some sort of enforcement action to stop the conduct. So you're allowed to choose.
So Joe, when a whistleblower raises a retaliation claim, what's the real remedy that they can expect or could look to receive?
For a federal employee that's been retaliated against for whistleblowing disclosures, there's really two types of remedies. One is what we call corrective action, and the other is monetary damages. So corrective action simply means the agency can be ordered to undo whatever it is they did. If the employee was terminated, the agency can be ordered to put them back into their position. If they were demoted, they can be ordered to put them back to the grade that they were in before the retaliation. So that's the corrective aspect. That's a corrective remedy that can be taken. And the other is monetary damages. That could be back pay. If the person, again, has been demoted or suspended or terminated, the agency would be ordered to not only put them back to their position, but also pay them the back pay that they lost as a result of the retaliation. And it could also mean damages for mental and emotional distress if that's something that occurred with that employee.
It may not always be practical, or someone may not want to go back into a position where they've been retaliated against. Are there other ways that the federal government can handle putting them in a similarly situated place, but not exactly working with the same folks?
And that can be part of the corrective action. So as part of the corrective action, the person can be put back into their position, and it may be that the individual who retaliated against them is removed from that position or is reassigned. So that can be done. Oftentimes in these cases, there is a negotiated settlement agreement that's entered into, and it may be that that employee is placed in another office or another department so that they don't have to go back and work with the same individuals who retaliated against them.
And Matt, are there similar remedies in the private sector?
I'd say there's similar remedies in the private sector. They're probably more generous in the private sector than they are in the federal sector. Some of the best whistleblower retaliation protections provide for back pay damages, but they also double those damages once calculated. And the idea behind that is we want to punish employers who retaliate against these people who are bringing these important matters of public concern forward. Like in the federal sector, you can recover awards of compensatory damages for emotional distress or potentially harm to professional reputation. And I think it's probably the case, and you can correct me, but I think jury awards for compensatory damages in the private sector are more likely than not going to be more substantial than in the federal sector. I think it's maybe a function of how those are awarded. And then finally, punitive damages are available under a very select few whistleblower retaliation laws, a couple of state whistleblower protections, and that could be a huge stick to wield for a whistleblower who's been subjected to retaliation, because these awards are designed to punish employers who do this sort of thing if they engaged in the conduct willfully or maliciously, and the awards can be in the many millions of dollars. So that's something that I think is available in the private sector, but again, it's relatively rare, but not necessarily in the federal sector. And awards of reinstatement are also on the table in the private sector. If reinstatement, like you said, might not be practical, maybe the well has been poisoned and you just can't unring the bell, then you might negotiate some sort of monetary payment in lieu of reinstatement, or the judge could order front pay in lieu of reinstatement, and that could be substantial as well, 3, 4, 5 years of total compensation projected going forward. So the remedies can be robust.
Joe, for federal employees, do you have to disclose your name? Are there any anonymous ways of reporting alleged criminal acts?
There are ways that federal employees can make a report and remain anonymous. It really just depends on who they make the report to. So, for example, if they're reporting it to their supervisor or up the supervisory chain, then they're probably not going to remain anonymous at that point, because it's going to be clear to everyone who made the disclosure. But most inspector general's offices allow for anonymous reporting. A lot of IG offices have a hotline that employees can call, and we've seen that happen where an employee could be in some other part of the country, calls the IG hotline, and it's handled by the Inspector General's office in Washington, and the case is investigated and some action is taken, and they may never even know who made that initial report. So that it can work that way. If an employee reports to the Office of Special Counsel, in most cases they can also remain anonymous in that procedure.
If an anonymous report is made, can that impact whether you recover under whistleblower protections?
Well, it is going to make a difference, because typically what happens is the person does not remain anonymous, or somehow their identity is disclosed, and that's how they end up being retaliated against. If the agency can show that the report was made anonymously and the deciding officials had no idea that this person had even made the report, then they're going to have a strong defense to the whistleblower retaliation claim. They're going to say, we didn't retaliate against this person, we didn't even know they were a whistleblower. So that's going to make a big difference.
Matt, I've got to ask you, is there anything that is of particular import that you think people should know if they're considering raising a whistleblower claim in the private sector?
Yeah, I think that it's a huge decision to make. It has career-altering implications, and if you're going to do it, it's best to consult with counsel who have experience advising people in these kinds of cases. One false step could result in undermining the whistleblower retaliation claim that's later litigated in court. The collection of documents is a huge issue in what we do. Whistleblowers want to gather evidence. Sometimes that's permissible, other times it's not, and employers will sue employees on that basis. So it's always important to be aware of the minefields, and the best way to do that is to ensure that you receive good counsel from lawyers on the front end who can maximize your chances to be protected under the law.
And Joe, any last pitfalls for folks who are federal employees?
Well, I think the same would be true for federal employees. It's important for employees who are considering making a protected disclosure to know what their rights are in terms of who they can report to, whether they're going to remain anonymous, what could happen as a result of that. And it's always wise for a federal worker to consult with an attorney in that process to help them through the process and to avoid those types of pitfalls.
Unfortunately, we're out of time. I'd like to thank our guests, Joe Creed and Matt Stiff, for taking time to educate us on whistleblower law. If you want to know more about me or either of our guests, please look us up on our respective websites. www.bramnickcreed.com for Joe Creed and www.kmblegal.com for Matt Stiff and www.jgllaw.com for me. Let us know what you think of the show and what topics you would like to see covered in the future by emailing us at lawschoolforthepublic@gmail.com. Please join us for future shows in our Law School for the Public series, which explores various and timely legal topics. On behalf of the Bar Association of Montgomery County, we look forward to being with you again. I'm Ann Grover. Thank you.